If you're listening, a will is really a backup plan. It is not plan A. Where I blow people's minds when they come in for estate planning is telling them that a will does absolutely nothing in the state of Missouri to avoid probate. The sole purpose of that document is actually...
Welcome to In Good Company, Elder Care in Your Backyard, the podcast that brings local perspective on aging, caregiving, and healthcare right to your ears. I'm John Ray.
And I'm Spencer Ernst. Every week, we talk with the people on the front lines, all making elder care accessible to you. Rachel Fortenberry is the founder of Fortified Elder Law and a dedicated elder law attorney. She transitioned from a career as a prosecutor into elder law to help families plan for Medicaid, protect assets, and secure peace of mind during life's most vulnerable moments. Her work focuses on proactive legal planning, education, and advocacy, guiding families with clarity and compassion. Rachel, thank you so much for joining us today.
Thank you so much for having me.
We're so glad you're here. So wide variety of background. How did you get into elder law?
Well, so I started out as a prosecutor. My main objective was to help people. And I thought that would be a really great path to helping a lot of people is, people who are victims of crime, helping them out in one of the most difficult times of their life. But when I got into the prosecutor's office, I was there for 3 years. That's how I started my career. I really saw that what I was doing is I was reacting to something that had already taken place, that had already happened. And so my client was actually the state of Missouri. So the victims of crimes, they were not my clients. And so I didn't kind of have that one-on-one connection with them. And I really just felt like I wanted to move into something that was a lot more, that I was making more of an impact. So eventually, I thought I wanted to be an estate planning attorney. And so I started at this new job. And she said, well, I don't really need help with estate planning. I need help with my Medicaid practice. And I didn't know what Medicaid was. I didn't know what the difference between Medicare and Medicaid was. And my first week on the job, I got to sit in a consultation with a married couple who came in, and we were telling them about how they didn't have to give up everything because one of them was going into the nursing home. They didn't have to lose half their assets or all of their assets. We could actually save everything to a healthy spouse using Medicaid's own rules. And I completely fell in love with it. My husband and we went out to breakfast that weekend, and I'm like, I got to tell you about this new job and how great it is. And I really knew from that moment that I had found my professional purpose. And I've been doing it ever since. So I've been an attorney for 10 years, and I've been doing elder law and estate planning for 5. So I absolutely love my job, and I'm so happy I stumbled into it when I didn't really know where my path was going to go.
So many of us in elder care around no matter what area of elder care, wind up sometimes finding our way by complete accident into this field. But I'm really glad you got into it. So you mentioned estate planning versus a Medicaid practice. Can you kind of dig into if those things are tied together in any way, what are the differences?
Sure. So elder law is kind of all encompassing of really anything that affects the elderly or seniors, but primarily people who focus on elder law. What that really is the intersection of estate planning and government benefits. So elder law attorneys usually are also doing special needs planning. So for people who are mentally, impaired or, have kids with special needs, we can do trusts for that. But estate planning is something that obviously affects everyone. Everyone over the age of 18 needs estate planning, but it gets different when you're older and you're actually looking at, you've retired and you kind of see what you have, and you're really wanting to do more proactive planning to protect your assets and to protect yourself and your family while you're still alive. So estate planning, with that kind of intersection of things while you're alive, that's where elder law and government benefits really come into play.
Okay. So I have a few questions that dig into the timing of things.
Mm-hmm.
So you may have somebody who's trying to plan way ahead, and then you may have somebody who they had one of the spouses had a medical issue that came up.
Oh, yeah, absolutely. So when we have long-term planning, and I'm really kind of talking about when we have more than 5 years. So,
Okay.
So I'm going to kind of back up just a little bit.
Yeah, please
talk
do.
about why we even care about this type of planning. So most people don't have long-term health insurance, or long-term care insurance, I should say. And so if you don't have long-term care insurance, if someone has to go into long-term care, so a skilled nursing facility, or they're potentially wanting in-home health care, really one of the only programs that will help you pay for that is Medicaid. So Medicaid is a federal and a state program. And so Medicaid has very strict rules into how you can become eligible for that. So you have to be medically eligible and you have to be financially eligible. And to be financially eligible, you have to have your assets less than $6,000. Right now in 2025, it's $6,068.68 or 28 cents. It changes. But so that's not a lot of money. And so how you get down to that $6,000 really, really matters. And what Medicaid does is if you go on that program, they will typically pay the difference between your income and the cost of your care. In the state of Missouri, that's about $8,000 a month. That's astronomical. That's how much a nursing home costs. And Social Security is generally the only income people have. So that's $6,000 that Medicaid could potentially be covering. So that's why we care about it. We care about it because if you have to go into a facility, which we hope no one ever has to, but if you do, we want to make sure that we're doing everything we can to protect your assets and protect your families if that happens. So 5-year look back. Medicaid looks back 5 years to see if you've done any gifting or transferring of assets to eventually qualify for Medicaid. So that's where I kind of break my planning down into, do we have at least 5 years before someone's going into a facility? Or is someone going next month? Is someone currently in? And that's kind of the two situations that you described. So if we have more than 5 years, we have a lot more options available to us, because if we're going to apply for Medicaid, they're not going to see any of the planning that we do. We still disclose everything that we do eventually to Medicaid, but it's not within their 5-year look back. So in that kind of situation, I talk to my clients a lot about gifting strategies, if that's something that we want to do. And most people don't want to gift outright. But we also talk about trusts, and specifically Medicaid Asset Protection Trust and things that can shelter and protect assets to where they're not countable for Medicaid purposes, but they're safe and preserved for inheritance for our children. So that's what we do for 5-year planning. If we don't have that, unfortunately, there's a lot of financial advisors. There's a lot of people that are health insurance advisors that are not familiar with the fact that we can do what they call crisis planning, which is we can do things to protect and preserve assets if someone's going into the nursing home or is already there and we don't have 5 years. Okay. So in that sort of situation, we can transfer assets to a healthy spouse We can transfer assets to a disabled child. There's lots of little caveats and loopholes that are written into law, but a lot of times we're even potentially gifting some of that money, some of those assets, knowing there's going to be consequences down with Medicaid, but doing it anyway, knowing what those consequences are going to be.
Okay. Wow, that's a lot. That's a lot. So let's break that down just a little bit, just so some people might have some ideas on maybe some examples of how you've handled that differently for different people based on where they're at.
Sure. So for example, when I have a married couple who come into my office and they're in their late 60s or their early 70s, even late 70s, and they have a home. So they have, let's say, $200,000, $300,000 in savings, which is not, especially with my clients, that's pretty normal. And then they also have their home. So their home is by far their biggest asset. And they're also not really tapping into what that home is worth. So in that situation, we'll talk about potentially putting together a Medicaid asset protection trust to put their home into. So the Medicaid Asset Protection Trust, how it works for Medicaid protection is that home is going to go in there. The person who's in charge of their trust is not going to be them. They're not going to be the trustee of the trust. They're going to basically hand over those keys to somebody else. It's usually one of their children, their most trusted child. And they're also not allowed to be a beneficiary of that trust. So they can still live in the house. And they pay rent on the house too. So they do the maintenance and upkeep on the house. They pay the homeowner's insurance. They pay the taxes. And so that's their rent. But the trust is separate from them. They have no control. They're not a beneficiary of it. And that's who owns the house. And so that's how it's a separate asset and it's not countable against them for Medicaid purposes. And so they can still, buy, if they want to downsize their house, their kid can sell their house for them, purchase a new house in the name of the trust. And as long as that's still under the umbrella of their trust, that's going to be protected. And we like doing houses because houses, you typically you're not trying to get any of the equity in your home normally in retirement. It's just an asset that's sitting there and not usually doing anything for you.
It totally makes sense. You mentioned building a trust and putting that trust in the hands of a trusted child, normally a trusted child. I have to ask, is there any other options besides a relative? Is there, like a company or somebody that I don't want to say maybe a little less biased, but I mean, that's their job is to handle trusts, kind of like some companies handle probates and so forth.
So there are companies that would help with Medicaid asset protection trusts. There's not too many that would take on that kind of burden.
Right.
But if it generally, we generally choose a child or a family member or a friend just because of how life ends up happening and working out. And so if we have a client who doesn't have a trusted individual to do things like that, it's probably not the best plan for them in general.
Okay.
So
yeah, that was going to be my next question is have you run into a situation where you've had somebody come to you and they have to pick a favorite kid, or maybe, it's not a situation where they feel comfortable necessarily handing that off. And then I guess my next layer of question is that even if they do have a child that can take that on, or a family member, are there other protections in place to make sure? Because I'm assuming once that transition happens, that transfer happens, that trustee must be then trusted. And are there any other protections in place to make sure that the assets that are in that trust are handled to the way that individual wanted them to be handled?
So, kind of just to answer like your first part of that, there's a lot of farmers who do not want to give up control over their trust, or don't have a person who they believe that they can kind of pass it on to, that will be as effective as they are. So that happens a lot. And it is obviously there's a lot of high risk involved in a trust like this. So it's also really important to be talking with an attorney who's also telling you about the risks involved, because these are irrevocable trusts. So they can't be changed, or it's very, very difficult to change them once you put them in place.
Okay.
So there are protections, but still, again, it's risky.
Okay.
The trustee has a fiduciary duty to make sure that they're doing everything in the best interest of the beneficiaries of the trust. They're not supposed to be selling. You have homestead protections when your house is in the trust, that they're not supposed to be selling it out from under you, that you're renting that property, right?
Right.
But typically, since you're not the beneficiary of the trust, you've given up control over that property. So it is a big trade-off of whether or not that's the right fit for you. And if it's not the right fit for you, we still always have that crisis planning tool.
Sure.
That if someone goes in a nursing home, we still have things we can do.
So let's talk about the difference in value, I guess, for one versus another. Let's say you've got a couple and they have, a trusted child that's, an angel, and, does everything perfect. And that's a great situation. They feel great about it and they follow that. And let me just use your example earlier. They have $300,000 in the bank and they have a great house. And then you have the other couple that it's an emergency. It's emergent. It needs to happen soon. And they're the same exact thing, $300,000 in the bank. They have a nice house. What are the value of protecting assets difference between those two, of the one that pre-planned 5 years and then the one that had to wait for an emergency?
Sure. So in that sort of situation, the value saved is going to be actually pretty minimal. We typically can preserve their entire life savings to the healthy spouse. So there's some caveats. There's some, everyone's situation is different, but for the most part, generally clients that I see, we can do that. And the house isn't a countable asset in order to get someone approved for Medicaid. They don't count it as part of that $6,000 limit for the person trying to go on Medicaid. They can file a lien against the house. So when you're married, your healthy spouse is living in the house, they're not able to file a lien until and unless that spouse passes away. So that's what the risk becomes when you're a married couple, is that the healthy spouse is living in the house and they could pass away, and then Medicaid could attach a lien to get paid back for everything that they've paid for the sick spouse. So that's something that we're generally trying to prevent, because Medicaid does have a legal right to try to, even if that house passes to kids with a beneficiary deed or something like that, Medicaid can legally still try to come after it.
Okay.
So whether or not they do is another matter, but that's what we're trying to prevent. Where you have a really big difference in how much money we can save is when you have a single person. So someone who's a widow or widower, or, divorced or never married. In a situation like that, we can save substantially more because the house is already protected. So, and that's again because of that lien Medicaid puts on things. So while it's not a countable asset to get someone on Medicaid, we always, when we have a single person, we're looking at how we preserve the house or how we preserve as much of it as possible. So we're generally selling it or transferring it to kids. And if we've already given the house away 5 years ago or more into that Medicaid Asset Protection Trust, it's already safe and we don't have to worry about protecting it in a crisis situation.
So pre 5 years, it's guaranteed safe. After the 5 years, there's still some risk there and you guys are jumping through hoops to try to help them mitigate that risk.
Right. Yeah.
Okay.
And it's obviously it's very case by case.
Now, we used a very specific example with a dollar amount that you said is pretty common for couples that are coming to you. I'm assuming that there might be a cutoff where you're like, well, Medicaid doesn't look like that's going to be, necessarily a possibility if it's urgent. They have too many assets in that particular case. Do you run into that very often?
I do run into that. I've ran into that quite a lot this week, actually. Several people come in that have over $1 million. And so I'm talking to them about their options. And obviously, this type of Medicaid planning, it's not for everyone. Typically, on a married couple, I'm talking about being able to preserve and protect all of those assets over. If they're over a certain amount of money, it's generally the way that I do things. There's a lot more risk involved. The more money that they have, typically, where we kind of start running into that problem is when they have about $600,000, $700,000 or more. Okay. And so there's still options, but it's not quite as clean cut as it is for people with, $300,000, $200,000.
Right.
So,
right.
Because
go ahead.
Well, because the system wasn't designed to be for those people who have
Sure.
$600,000 or $700,000.
That totally makes sense. And I think because I think a lot of people out there this is very confusing to them. They're like, I hope to never need this. But, one of the things that we're really pushing is trying to help bring some clarity around what things they can do now to protect themselves. And you mentioned, long-term care insurance being one area. And so when somebody's above a certain level of assets, it sounds like maybe that's a better direction to go, trying to make sure that they're investing in, a good long-term care policy to protect those assets potentially by, it absorbing the lion's share of the cost of that higher level of care. Is that kind of the direction you move your people, or are there other things you suggest?
I think that long-term care insurance is a very good thing for people to look at, or life insurance policies that have long-term care insurance riders. So, and I'm not an insurance agent, so I can't kind of speak to a lot of those things. And honestly, that's what, with the Medicaid Asset Protection Trust, I kind of view that as another type of insurance, that if long-term care insurance usually is limited in how long it'll pay out and how much. What I try to tell people, especially when I'm out giving presentations, is that you should be concerned, at least in order to go and talk to an attorney, especially one that does elder law. But I wouldn't be so concerned that you're so frightened of it that you try to lock up all of your things, that you try to put everything that you own into this Medicaid asset protection trust. We're living longer. Science is letting us live longer. And so therefore, we're also a lot of times needing this longer term care. Yeah. But the money that you have, I always tell my clients, it's like, let's put this aside to know that you have this inheritance for your kids preserved and it's there. Right. But all of this other money really should be used for yourself, to enjoy your life, to go on trips, to enjoy your grandkids, and not worry so much because you've taken care of your kids kind of with this set aside.
This is great information because quite honestly, I think some people don't necessarily look at this to have a plan in place and, start talking about, asset protection and figuring out, because it's just like you said, I mean, ultimately, one of the spouses needs a place to live and they still are planning to remain retired long term. And so, and that's, I think our biggest concern is that, that there are situations where people have to scramble to figure out, how they're going to make it from that point on, and going into it, understanding what could happen. So, I don't know if this is worst case scenario, but going into a skilled nursing facility and having to pay for that privately long term, a decade or more sometimes, if depending on the issue, does everybody have to drastically change their lifestyle, or are we protecting them enough so that they can still remain where they're at and stay in their house and still have enough of their retirement to be able to live comfortably without having to go back to work or something.
I don't really love that our system is kind of designed to, you can qualify for this program in a skilled nursing home. There is a Medicaid program for assisted living, but Medicaid will only provide $292 right now for that a month. So that's not a lot. And in-home health care, they do help provide for in-home health care, but that's usually about 20, 40, 50 hours a week. It really depends on the situation, but 50 hours a week for someone who needs 24-hour in-home care, that's a drop in the bucket. I really wish there was more support for our families who are trying to, age in place, who are trying to not go. A lot of people that are in these skilled facilities, that's not always the level of care that they need, but they
don't need that much care.
Right. But they're going there because of financial reasons. Who knows, that might change in years as we have more people who are needing these facilities. But yeah.
I totally agree. And you're not the first guest on that has mentioned that. Why does it have to be all or nothing? There's several levels of care that are much less expensive. Why can't Medicaid pay for these lower, less expensive levels of care instead of paying the most expensive level of care when that individual doesn't need that? I 100% agree. And, the thing that I want to just kind of bring up, because obviously this could impact what you do, is the proposed Medicaid cuts. And I don't know if, as a group, the, elder care attorneys are already discussing, what's potentially coming down the pike. I know in the healthcare world, we don't really know how things are going to get handled. We assume eligibility will get impacted by this. And, some people won't qualify for the future Medicaid? What are things that are your thoughts on those issues?
Well, right now, the proposed, well, it's not even proposed changes. They're what have been passed into law. The impact for vendor Medicaid, which is the nursing home Medicaid, is that they're no longer limiting how many, there was a specific amount of staff that had to be in place at facilities that they've eliminated that, or at least they're no longer having that same limit that they did. They're putting a cap on exemptions for homes, which isn't, at least right now, going to affect Missouri because the cap is larger than the one that we currently have. They're also upping the reviews to make sure that people remain Medicaid eligible, financially eligible, from once a year to twice a year. And then they're also limiting in how far they will go back to cover someone on Medicaid. Right now, we can ask them to look back for the prior quarter, so 3 months, and starting in January of 2027, so a whole year from now, they will have it to where it's only 1 month. They can only look back 1 month. So
Okay.
That's really the big impacts on vendor, because obviously you can't have work limits or impositions on people who are in a nursing home.
Yeah.
So
Yes.
that'd be difficult.
That would be.
But we don't know how it's going to affect the program as a whole. I do think that they're going to get more strict. I think that that's probably going to happen. And so, it was something that I was really concerned. I'm very concerned about it for my clients. But, that's why, this is something that, so the National Organization for Elder Law Attorneys is called NALA. So that stands for National Academy of Elder Law Attorneys. And so that's something that we're all taking very, very seriously. There's been multiple discussions in the Missouri chapter. I know that we've talked about it a lot, of how this is going to impact. But really what I see is even more of a need for people to need and utilize elder law attorneys. You said a little bit ago, this is really super complicated. That's one of the reasons I love this job so much, is because I love how complicated it is. I love how there's changes, there's things that happen, and everybody's story is different and everybody's facts are different. That's why it's also important. That's my job, is to know all of the nuances. That's why you go to an attorney who can take the and at least distill it down.
Yeah.
To tell the government agency how you can qualify for that program. So
thank goodness you guys are out there for us. So having said that, it being complicated, when you have people come to you, is there anything that kind of like some myths or some things that they're really surprised by when they come talk to you for the first time?
I think that they're usually surprised, married couples, when I have a spouse come in, because someone has to go into a facility, is that we're generally able to get them onto Medicaid. Medicaid would start picking up the tab quickly. And we can usually get people eligible and on Medicaid in a short period of time. And so that's something. They're also surprised in how much Medicaid will cover.
When you have somebody come to you, is it typically when somebody has already entered the nursing home, or that they already had talks with you prior to that?
I am starting to have more talks with people who have spoken with me before. I really want people to feel like they need to go to an elder law attorney, especially when a diagnosis has been made. We know that someone has been diagnosed with Alzheimer's or dementia or Parkinson's, or who their health is declining. It's really important to come and talk to an attorney then, and we can make sure to put things in place. We haven't even talked about, powers of attorney and how important those things are. But I'm starting to see more and more of those people come back. But I also, I have a lot of nursing homes that send people our way. A lot of times it's the people who aren't coming from those specific places that are also surprised to know that there's ways that we can, spend a person down to get them financially eligible. That's not actually, spending and the money and watching it go out the window.
So help us understand that a little better.
So most people, when they come in here and they're talking about spending that money down, so getting down to that $6,000 level, or, a spouse will have a level that they have to get to as well. They know that they can usually make home repairs, they can purchase things, they can buy a car, they can buy a prepaid burial plan. But they don't know the money saving tools that we have with Medicaid compliant promissory notes, Medicaid compliant annuities. Those are a way of turning assets into a non-countable income stream for a healthy spouse.
So, and I'm assuming some people might know what this is, but the promissory note and the annuity, I've heard of an annuity, but the promissory note, what is that?
So a Medicaid compliant promissory note is a way of, I'm quoting air quotes, lending your kids money, and having them pay you back that funds in a period of time.
I see.
And so it has to be set up in a certain way. That's also putting a lot of trust in your children to be able to pay you back for those as well. Right. But that's a tool that we can use. A Medicaid annuity is kind of the same thing, except you're lending your money to a company, and they're paying you back in annuity payments over a period of time. Those also have to be Medicaid compliant, and those get a little bit complicated because if you're wanting like a shorter term to get money back in a quicker way, there's kind of few companies in the United States that do those.
Is there a set dollar amount to say this is Medicaid compliant, or is it vary per person?
I use Medicaid compliant annuities a lot. I use promissory notes every now and then. Usually if people have less money, like under $60,000, I'll lean towards a promissory note.
Okay.
If they have more than that, I will lean towards a Medicaid compliant annuity, just because of how much money we would be giving kids. That's really tempting. A lot of times when I do promissory notes, they're a little bit complicated for families, and they just kind of prefer to buy an annuity from a company who does a direct deposit, and it's kind of all taken care of.
Right. So there's kind of middlemen that can make this a lot less, I guess, complicated, or
yeah. And those tools are really used to get someone Medicaid eligible. Right. So that's not something that we use for a 5-year, 2-year, 3-year plan. That's something that's a crisis situation.
I see. You had mentioned power of attorney earlier. Some folks might know what that is and why it's important. Can you help us understand that better?
Yeah, absolutely. So powers of attorney, and I say powers because there's typically 2 different types, are a way of appointing someone to be your voice. So the one that most people are familiar with is a healthcare power of attorney. And so that usually only comes into effect when you're not able to make your healthcare decisions anymore. But you have told the hospital, you've told the doctors, or you've told the world in your healthcare power of attorney who you want to be your voice and to make your medical decisions. And so that's usually paired with what's called a living will or a physician's directive that says, these are my end of life choices. I don't want to be put on a feeding tube if I'm most likely not going to be able to come out of whatever state I'm in. I don't want to have life prolonging procedures done. Those coupled together are called an advance directive, the healthcare power of attorney, and that living will. And so that is your all of your wishes, telling the doctors who you want in charge and what your final wishes are. The other power of attorney, which I actually think is the most important one, because people forget it all the time, is the general durable power of attorney. A lot of people call it the financial power of attorney. So it's general for all purposes, really except for health, the health decisions. And it's durable because it'll survive even if you become incapacitated. So those are incredibly important because it's a permission slip. So you're appointing someone to be able to step into your shoes and act on your behalf in different situations. They can go to the bank and withdraw money or deposit money. They can get bank records. They can sign checks. They can get into your digital accounts. They can get in, talk to your health insurance agent. There's lots of different things that they can do. It's kind of the kitchen sink of documents. And so if you're listening and you're like, I have a general durable power of attorney, and your general durable power of attorney is 2 pages long or 7 pages long, that is not a very good power of attorney. But typically when clients are coming in here, I'm an elder law attorney, so we're talking about seniors. We're wanting to put something in place to make sure that family members or your spouse has the ability to do anything that they need to do to help you in the future. And so a lot of times when they're those really thin documents, there's not a lot of explicit powers in them. It's just very general. And we come into problems with banks, or if your child is trying to sell your house because you've gone into a nursing home, if it doesn't have the right language in there, title companies are going to have problems with things. So we want to make sure that we're talking with an attorney who is looking at these as kind of being maybe the last power of attorney that you're going to have before you pass.
So I shouldn't go online and just Google power of attorney and just fill out the form or whatever they have online.
No.
I need to go to an attorney. It makes total sense now.
Yeah. Well, I mean, and I know that attorneys have such a stellar reputation, right? So,
I did not say that. Officially did not say that.
Yeah. But that's definitely something that you want to make sure it's really protecting you and your family. You really want to make sure that that's something that you've actually talked to someone who knows what's potentially going to come down the road there. Right.
Because if somebody has a family attorney, so to speak, that they've used for years, but they don't specialize in this, it's probably best to go to somebody who really does specialize in elder law.
Right. You don't want to go to the attorney that does family law, personal injury, slip and falls, who does criminal defense. Oh yeah, and I also do estate planning.
Yeah.
You don't want to go to the jack of all trades.
Right.
So yeah.
That makes total sense. When people think of estate planning, is that the same as a will?
A will is part of a well-rounded estate plan.
Okay. And so can you help me understand the components of a great estate plan, and what is a will and how does it fit into that?
I think that a well-rounded estate plan, first of all, is protections for your family while you're alive, which that would be your healthcare power of attorney and your general durable power of attorney. And then it's also protections for your family after you've passed away. So a will is part of that, but a will is really a backup plan. It is not plan A, because where I blow people's minds when they come in for estate planning is telling them that a will does absolutely nothing in the state of Missouri to avoid probate. It is not a document that is designed to avoid probate. It is the sole purpose of that document is actually to use in probate. So it is a set of instructions for the probate court and how you want your things distributed, who you want in charge, which again, it's important because we want to have a backup plan just in case something goes through probate. But how you avoid probate is either by having a properly set up and funded trust document, or to have the proper beneficiary designations in the state of Missouri for different things. And what I mean by that, beneficiary designations are telling your bank, these are my beneficiaries, who I want my account to go to when I pass away, telling the state of Missouri on your title who the transfer on death or the TOD is, telling the county in the recorder of deeds office, filing a beneficiary deed saying, this is who I want to have my house after I pass away.
Wow. There's a lot to it, isn't there? So if somebody comes in and they're like, I want the works, I want to cover all my bases, how long does something like this take to go from beginning to end to put a really good estate plan together?
That'll vary by the different offices that you go to. I know, it's typically probably a several month long process. I know some places who are much longer than others, and it just depends on how their internal systems are. With my office, it generally takes a while to kind of get through, to get an appointment with me. And then we usually will do, once you have an appointment with me, to when we're signing documents, we try to do that in about 30 days or about a month. When you're ready to make an estate plan, it's not going to stay on the top of your mind forever. Like right. I tell people all the time, it's like, I understand coming to see me is like going to the dentist. You don't want to do it. At best case scenario, we're talking about what happens after you pass away, after you die. So that is not a fun appointment. If you're ready to go, then now is the time to get it done versus 6 months from now when you're like, oh yeah, I'm not really you get busy and things happen. We also have different offices will help people fund, they'll help people change beneficiaries or do things. Or other offices will give you like a list of things to do and maybe follow up with you to make sure that you've done those things.
That totally makes sense. And you're doing a great job of walking us through this. We had a guest on where he had described a situation with a family that nobody had power of attorney, and the mother was going through dementia, wound up in the hospital, and the hospital didn't want to release that individual to anyone that didn't have some sort of proof that they were allowed to, whether or not they were a kid or not, it didn't matter. Have you run into any situations where somebody didn't have the power of attorney in place and they were kind of in a situation that was just like they had to go a different route in order to try to, because the person themselves didn't have the mental capacity to deem someone their representative.
Absolutely. I've run into that a lot. So we had a family, a husband and wife who moved from California here into Missouri. And so she needed to get on different health insurance. And he didn't have power of attorney over her, but she had advanced dementia. And so there was no way that he could sign up to get her on health insurance. And she needed she needed to go to the doctor. She needed to get prescriptions. She needed to establish care here. And so we had to open a guardianship for them. Wow. And that's the alternative. If you don't have a power of attorney, and someone does not have the ability to create a power of attorney, to execute, to sign a power of attorney document, then you have to get a guardianship. And so that is applying to the court that this person isn't able to take care of themselves anymore and doesn't have the ability to do that. It's a costly process because you have to hire an attorney to help you do it. And it's a lengthy process. It's not something that you can just go down to the courthouse, file, and then get something back, because you're talking about you're taking someone's rights away when you're becoming guardian, because you're saying that you're the person in charge of them. So
does your office do guardianships?
So my office has been blessed to be busy enough with the Medicaid applications and helping people protect and preserve assets that, guardianship isn't something that we kind of are set up to do, because we're just spending so much time in that. But we do have several attorneys in town that are phenomenal that we refer people to. So when people call us, we send them there.
I'm 54. I do have a trust myself. My wife and I do. But there's probably aspects of this we need to circle back on and make sure that we have more detail in there, because you brought up a lot of things and I'm like, ooh, I don't know if we have that, and all these other things to circle back on. But at what age do you feel like it's critical that you have this power of attorney, this estate plan put together for these situations?
When your child turns 18, it is critical to get a healthcare power of attorney done, in my opinion. Part of the reason, well, not the only reason I'm saying that, but I'm on the board. I'm the president of the board for Hospice Foundation for Outreach. And so our slogan is that we're preparing communities for life's end. And one of the things that we really push is we have a bucket list +1 initiative, where it's a bucket list of things you want to do before you pass away, you die. But it also, the +1 is that it has an advance directive, so a healthcare power of attorney and a living will. And those are designed, those bucket list +1s, they're designed for people over the age of 18. They're bright colors. College students made them, designed them. And because when you have a kid going off to college and they're 18, they're their own person. And so you want to make sure that you have a document in place that if something happens to them, you're able to make healthcare decisions for them. You're able to get access to their HIPAA protected documents so you can know what's going on. So really anybody over the age of 18 needs a healthcare directive.
Okay.
But practically speaking, we know that 18-year-olds are not going to get wills. They're not going to get trusts, right? But they probably do have an estate, just so you know. If you have a bank account, if you have a car, you have an estate. Once you have children, that's kind of another milestone that it's really important to have estate planning put into place, because then if with kids, you want to make sure that kids are able to inherit your money without needing a lot of complicated things with the court coming into play, like a conservatorship, because they're inheriting money. Most people are going to be over the age of having little bitty kids. And so the next kind of milestone is really when you're nearing retirement age. That's a wonderful time to really know, you're more established, what you have, and you kind of know your kids' personalities a little bit more. And so that's a great time to set up like your preliminary things. You should always, everyone, no matter what age they are, can be doing those beneficiary things, putting beneficiaries on bank accounts, putting a TOD on their car, making a beneficiary deed for their house. But retirement age is a great time to start thinking about potentially doing a trust. And then when we're talking about those Medicaid asset protection trusts, like I was talking about earlier, I love talking to people who are in their late 60s or in their 70s about doing those.
Okay.
Because prior to that, I think it's not really much of a looming problem.
Right.
We typically don't do those once someone has hit 80. So getting it done, period, is good. You shouldn't feel bad if you're 95 years old and have never done estate planning.
Once you establish a great estate plan, and let's say you're younger and you hit these milestones, how often should you come back to maintenance that estate plan?
I think that you should look at it or think about it every 3 to 5 years. That's typically what a lot of attorneys say. It's also good every now and then there will be huge changes to the law that will make a difference. For example, like when the HIPAA regulations were passed, I've seen several powers of attorney, like healthcare powers of attorney, that don't have HIPAA language in them. So that's a really important, you just never know when that's going to happen. So a good checkup to come to the attorney's office is probably every 3 to 5 years.
One, I want to thank you for being on the board for the Hospice Foundation. I think that's a very special program. And I know hospice does a bit of this paperwork with families starting out. And I know it's just, kind of some of the basics, but do you work with hospices a lot to try to help make sure that, we're filling the gaps to make sure that we're covering all of our bases? I
have met with hospice organizations before and kind of talked through that. And that's something that I loved. I love educating people. It's one of my favorite things to do.
Yeah.
Because all of this information, I kind of feel like it's your right to know all of these things, and especially with how we can avoid probate and things. There's a lot of free things that people can do to avoid probate, and so I feel like it's people's right to know that. With hospice providers, what we're talking about with a lot is, do clients have these powers of attorney in place? So when their condition eventually deteriorates, that you're going to be able to still talk to someone, have someone appointed to be their voice. And so that's absolutely something I love talking to people about, and talking through questions that come up with healthcare providers and hospice providers a lot.
I love that. And I'm assuming that hospices are making referrals to you. Sometimes. So maybe that needs to happen more is what I'm asking.
Yeah.
Okay. Duly noted. Yeah. Okay. And so if somebody has a lot of questions, they just call your office?
Absolutely. We would love, and even if it's something that we cannot directly help with, we love being a resource for people to get them to the place that they need to go.
You cover so many contingencies, I guess, that I think are amazing things that were definitely not on my radar. And, I really, again, appreciate the work that you do, because I really think so often you just see the deer in the headlights with some of these families that are just, waylaid with a new diagnosis, like you mentioned, or, something's happened, their loved one's still in the hospital or going into skilled facility, and they're just, got sticker shock from finding out how much the skilled stay is going to, or the nursing home's going to be after their skilled stay is over, or, whatever it is. And, I think you're a critical part of the elder care team to bring about. And I hope that, with us getting, this out there, that we can have more and more, colleagues in the elder care world referring more folks your way, because it does have a lot of benefits, and peace of mind is part of it. That if people know that maybe they don't need it, all aspects of it right this second, at least having a conversation, sitting down, really kind of going through what needs to happen now, what'll happen if this happens or that happens, so they at least know who to pick up the phone and call and start the process on certain things. So yeah, I've actually learned so much in this conversation that I just have to say how much I appreciate the work that you do. And, I know things are changing drastically. We'd really like to stay in touch so that, as things unfold, we can circle back to the legal side of things and how that impacts, Medicaid changes or eligibility changes or whatever. We want to make sure that the people who we're trying to stay informed know how they need to respond to it or be able to help them in their personal situation.
Right.
Any final thoughts? Anything you want to share with people who are kind of out there and just maybe learning for the first time that, what a trust is and what a power of attorney is and all of those things?
When you start to see any sort of decline or a bad health diagnosis, to really encourage them to go talk to an attorney. Having that power of attorney put in place early, so that person can kind of step in seamlessly and start helping. It just makes a huge difference. And I see a lot of people who have the bad health diagnosis, and they wait until it's either almost too late or it is too late. And it's so incredibly important.
Absolutely. Well, we're definitely going to put your contact information, if that's okay, in the show notes, so that people can reach out and get to your website. And what's the best way for people to reach you?
They can either call my office, and I don't know if you want me to plug that phone number or not.
Yeah, go ahead.
It's 417-530-4529, or they can go to our website, which is fortifiedelderlaw.com.
Well, Rachel, again, thank you so much for being on this podcast. We have learned so much, and we will definitely have you back.
All right. Thank you so much for having me.
Wow. Spencer, what did you think? Rachel was amazing, wasn't she?
Well, absolutely. And I think the biggest takeaway that I learned is that the will is not the first line of defense. Having a will is a plan B. That was kind of shocking.
I know, me too. Me too. I think a lot of people are going to be shocked listening to this, because there's just so chock full of so much great information, and just things you never even thought of, just little things, trying to get insurance, dealing with a bank account, proving that you're the person that can take that person home with you when you need to after they've been in the hospital, so many little things that, really come up. And I think through that whole thing, I was taking all these notes, and I think some people might think I was asking the next question. I was actually writing them down for myself. I was like, oh boy, we better pull out that trust and look at it, because it probably is missing a lot of pieces. And it's great to go to a specialist that really focuses on this and deals with it day in and day out, because they have attention to detail. And I thought it was really important that she talked about don't go to a general practitioner. You want to go to somebody who specializes in this, who really knows it backwards and forwards, and is going to help, fill in all the blanks so that you don't miss something. Because in those situations where things are moving very quickly, they've been in the hospital or in the nursing home now, you're like, what am I going to do? Those things move very, very quickly. You have to make decisions really fast. And if you've had a conversation and talked about all the ins and outs of what could happen, it's just so much less stressful. I've talked to two sets of families, ones that went through this process in detail and ones that didn't. And the ones that went through the process are so much more relaxed. Like they went into these situations prepared. It's not that it's not stressful, but they can focus on their loved one more and their care and advocating for them. But when they're scrambling on all these other things, they can't pay attention to what's going on and be that advocate for their loved one because they're so overwhelmed with these other things.
Absolutely. And always remember, every 3 to 5 years, you got to check in with that attorney.
That's such good advice. Such good advice. Well, I think this was a great one, and I'm super glad we went through this.
Absolutely. If you enjoyed today's conversation, make sure to like and subscribe so you never miss an episode.
And we'd love to stay connected. Follow us on YouTube, Facebook, and on Instagram at In Good Company Elder Care Podcast.
You can also find us on X, formerly known as Twitter, at IGC Pod, and on TikTok at IGC Elder Care Podcast.
Thanks for tuning in to In Good Company, Elder Care in Your Backyard. I'm John Ray, and I've been joined by my amazing co-host, Spencer Ernst. Special thanks to our executive producer, Alex Wallace, for helping bring this show to life. Until next time, take care, and remember, you are always in good company.